Good afternoon. My name is Larry Forsyth. I'm the Senior HR and WHS Manager with Australian Business Consulting and Solutions. Welcome to the webinar on drug and alcohol policy and testing. Today's takeout for you and some of the messages that you can look to take away include examples of best practice for employers thinking of implementing drug and alcohol testing, potential workplace causes of drug and alcohol misuse, essential policies and documents you should have to mitigate risks, and what support structures you need to offer your employees. I suppose our research takes us to a place that we see the drug and alcohol testing in Australian workplaces has been quite a hot button and quite an issue for some time. For example, in 2011, we saw a landmark decision made by Fair Work Australia that gave Victorian employers the power to enforce compulsory drug and alcohol testing of their building sites, despite strong opposition from their unions. Ever since that, the battle has raged somewhat, and more recently, for your information, the Victorian government came to the forefront yet again. This time they were pushing for construction companies to be required to have drug and alcohol testing in place for workers doing government construction work. Once again, they were met with opposition. We now see that the construction, forestry, mining and energy unions slammed the proposal, and as an attack on construction workers, stating that no evidence of a drug and alcohol epidemic on construction sites was actually relevant or even existed, and therefore compulsory testing was not needed. I think based on some of that research and some of those findings is that it's pretty obvious that the construction sector is a large sector of employment where people are working on activities that can really be at a very high risk and quite dangerous. I suggest that it's an area where government is acquiring services and can therefore make decisions or requirements and conditions as part of that terms of agreement. So really, in essence, government acquire a whole range of services, really, such as legal and accounting, but there's not an inherent danger there. And other government employers, or employees, I should say, have taken that leap themselves. And what we've seen is that the NBN Co. were ingraining compulsory drug and alcohol testing in their organisation. Some of the NBN Co. offers support is certainly through counselling and rehabilitation to its employees who have failed tests. And at the end of those programs, for example, should that employee test negative, they are placed back in normal duties. But if they fail, a plan is put in place to regularly test the employee. And should further failure occur, then the person's future employment is considered. Well, I think it's important that testing of government employees, as an example, is one thing. My question would be about what is your company doing and what about the private sector and or even not-for-profit sector? And the question I pose could be, should corporations be testing their white-collar employees as well? So I'd be asking you, do you have an agreement in place as part of that employment contract, and are your policies currently relevant? So while we're seeing that white-collar drug and alcohol testing is possibly still in some murky areas, from a legal perspective, then we would be suggesting that one of the key questions any employer needs to ask themselves before undertaking workplace drug and alcohol testing is whether the company has contractual basis for doing so. And in that, if it is agreed up front, then the employer, all things being equal, has the right to apply the regime, and employees are expected to cooperate. When it comes to pre-employment screening, an employer is well within their rights to ask a prospective employee to undertake a test. However, the prospective employee also has the right to refuse that test. Given that the employer has power to make an employment decision, any refusal could count against the prospect in terms of gaining employment. So during employment, if the testing, I would suggest, has been agreed to and the employee refuses the test, then a failure to comply could be considered a breach of contract. And the question would then arise whether the employer should undertake legal action and perhaps seek dismissal. In that case, the employer would be in a position that they would need to argue breach of contract. But they would also have to demonstrate they undertook all correct steps leading to the dismissal so that they would not fall foul of the unfair dismissal laws. In other words, the employer needs to demonstrate that the dismissal was not harsh, unjust, or unreasonable. I would suggest that the mere fact of refusing to undertake a test does not mean the dismissal is fair. And there would be a range of considerations, including length of service, the risk posed by the failure to participate, and the circumstances of the employer, for example. So what happens if there is a positive test? And that's certainly something that many of you may be asking, and I've got a couple of questions around that going forward. So should it mean that if someone does fail a test, that there's automatic termination? It does need to be considered in context, and the question there would be, was it the first breach, for example? And what was the level of intoxication, and so on? Overall, I believe that best employers would need to be using testing as a disciplinary measure, and also as a behavioural issue, perhaps, and would offer support to the employee for rehabilitation, and to ensure that they are able to continue their employment risk-free, one might say. Some of that best practice is that, from a behavioural perspective, that what you would have in place would be that rehabilitation, that counsel. Many employers have employee frameworks for staff to be able to go to and talk to psychologists and employee assistance programs, because they do want to have risk-free environments and risk-free employment. So thinking about some of those signs and factors surrounding drug use and those broader organisational issues. Our research tells us that WorkCover breaks these down as some of the signs and factors, and they include frequent, prolonged and unexplained absences could be certainly a sign, involvement in accidents both on and off the job, perhaps erratic work patterns and reduced productivity, and possibly even indifference in personal hygiene. There could even be sudden mood changes, behavioural changes, deterioration of relationships, and even all the way down to dishonesty or theft. It's not sounding good. But in that way, if you are identifying these sorts of things happening in your workplace, then it could be important to seriously consider stricter policies around that testing. With all of that in mind, and with that being articulated, I think it's also a case where you need to think about what might be that ongoing punitive action, and is it really necessary? So let me suggest that enforcing a drug and alcohol testing regime does not necessarily mean that human resource people or managers, for example, will see a lot more turnover if their staff are coming to work intoxicated. Just like NBNCO's policy, punitive action is not always a necessary, I should say, excuse me. You don't have to introduce this testing, I would suggest, with the intention of having a mechanism to terminate your employees who might just fail that test. I would suggest more so that the purpose of testing is that you stop employees who are intoxicated or inebriated causing those risks. So for many good employers, what we're seeing is that they will have systems in place to help rehabilitate and assist employees to overcome addictions, be it alcoholism or drug addictions. And really, I would be suggesting that that should be the primary focus of any system that an organisation was to introduce. It's not about not necessarily to make sure employees are terminated, but wholeheartedly to assist them to comply with the requirement to attend work safely, which really, in the end, is what this is all about. I would also be suggesting that if drugs and alcohol have been detected in your workplace, then HR, managers, supervisors really should be ensuring there are robust policies in place to care for employees in the best possible way. While punitive action may be something to consider down the track, there are other remedies that can be put in place beforehand. And in that, you're attempting to support your employees and get them back to work and on track. Just some of those elements that you could actually be putting in place, certainly education and training. And so if you've had drugs and alcohol appearing in your workplace, then education and training of other staff would certainly be necessary and, in fact, possibly even essential. Employees really should be aware of the policies in place, and these may even need to be reviewed. And really, in the end result, people should understand them. They may not, in fact, read every word on the policy, but they need to know where to access them. And in that way, HR should provide employees with information about alcohol and drug-related harm in the workplace and other general information. Other interventions, certainly access to counselling and treatment, and so employers must ensure that adequate and appropriate counselling is available to employees, certainly with drug and alcohol problems. And I would be suggesting that when conducting drug testing, compulsory attendance at counselling, if indiscretions are found in that way, it may be on the way to helping combat that, and certainly a process that you could put in place that would be certainly a lot more positive and enable that employee to get back on track in a much more meaningful, purposeful and practical way. Other interventions, and certainly some of the best used to identify potential drug and alcohol problems and to really uncover that at-risk behavioural patterns, and in that way you can stop that problem from spiraling out of control. These interventions really will utilise other employees, possibly as change agents, and we've seen that happen in just a few of the organisations that we've been working with closely. These change agents, based on the premise that co-workers are in the best position to recognise and respond to employees with drug and alcohol problems, can be your eyes and ears. Trained employees can identify problems with their colleagues and intervene appropriately. And these are effective at identifying and addressing some of those problem behaviours. So it's important that you remember a few things here. And as soon as the employee presents at the workplace in an intoxicated state, if that is the case, the employer, the manager, the supervisor should direct the employee to an office where it will be made clear to the employee that equipment is not to be operated, for example, by any employee under the influence of drugs or alcohol, and that should also be stated in your policy, I would suggest. An official, really as a process, could be called to the office to act as a witness. If there is no official on site, then another employee could be called in to be that witness. If the employee needs an escort home, and it's not practical, then the employer certainly should be responsible and organise a taxi to take that employee home. I also think ultimately it's important to be alert around these things, and so failure to act for the general health and safety of all employees at the workplace is a breach of management responsibilities. So I would be suggesting the rule of no alcohol or drugs must be strictly enforced. The employer should not jeopardize their health and safety of the intoxicated employee. And so therefore, as employers and employees, there should be exercise in getting that employee to a safe place if this case was found. In saying that, you do need to consider the options, and so there is no question about whether the intoxicated employee can remain working if she or he cannot be allowed to do so. In that sense, summary or instant dismissal may be considered when there is a history of this type of behaviour and the employee has been warned before. So really, if your policy is in place and the employer has made its position and the severity of the penalties are clear, then summary dismissal may be an option even if the employee has no history of such behaviour. Really, in the end result, the employee should be verbally warned at the time of the incident, and this should be followed by a warning letter, assuming that summary dismissal is not being applied. So as for follow-up, and I know some of the questions have been framed around this. So as an employer, is summary dismissed then the employee's termination, and should it be arranged as soon as possible? Well, in this case, probably so. And if the employee has been verbally warned, a letter confirming the warning should be given to the employee on their return to work. The position of the employer excuse me, should be reinforced by a clear message to all employees without specific mention of the employee in question. And so in that way, it can stop any Chinese whispers entering the workplace. So in summary, it's very important that employees have a contractual basis for testing and ensuring that policies are in place and that they are adhered to and that everyone knows that they exist, that they understand them and they know where to access them. That pre-employment screening certainly can't be enforced, but the candidate may be regarded poorly for not complying. Remember that where there is no contract, common law principles certainly do apply. Failing a test is not grounds for immediate termination, and any termination must be in line with the Fair Work Australia Act. And finally, termination, remembering, must not be harsh, unjust, or unreasonable. Now, I've got some questions which I'm certainly happy to field. Let me just read one. How do you ensure managers who have access to drug and alcohol testing do not misuse or misunderstand the results? The question asks that the person had recently worked with a client who had made the decision to terminate an employee because antidepressants had shown up in their drug test. So again, really, it's about due process. It's about the policies and procedures that are in place. And if there's a framework for drug and alcohol testing as part of that contract, then it's certainly about giving that person not so much the benefit of the doubt, but it's about following that due process. And in that case, that you give them that opportunity to be rehabilitated, to bring them back into the workplace. Another question, how do we mitigate our risks with staff drinking at work Christmas parties? That is a popular question that certainly comes up at this time of the year. And again, I'd be saying that, and certainly suggesting that you follow due process and that your policies and procedures are there and framed around these sorts of events. It's certainly about how you communicate that out to your staff. And it's not just that policy and procedure. So it could be illustrated through emails and reminders leading into the event. Reminding people around what the process is and to ask them to drink responsibly, for example. Another question, at what stage do you have to offer counselling and what is the requirement for instant dismissal, even though you have a zero drug and alcohol policy and it is made to all new employees? In a way, I think that I've probably answered that question as part of the webinar scenarios here. I think it's about that if you identify in line with your policy that someone has come into the workplace and they have been intoxicated, then it's about applying that policy as quickly as possible. And so the requirement is that you bring it to the attention of the employee, you remove them from the workplace, and you take them to that place with a witness, and from there you proceed as to where and what sort of support you would give that employee, but certainly to enable them to know that you are aware. Another question, when an employee shows that they have a positive result, in brackets confirmed by a lab test, how long should you wait until allowing them back to work? They go on to ask, is it best to put a time on it or to get them retested until they can show a negative result? And if you get them retested, who pays for retesting? So about a three-question question there. So really it's about, if there is a positive result, how long should you wait until allowing them back to work? Well, really the point there is about that you don't want them to come back to work until it has been actually deemed and tested as negative. So depending, how quickly you can get that result, so it could be 24 hours, 48 hours, it might be a week, depending on how quickly your process is around getting that result. Is it best to put a time frame on it before the retesting? Well, I'd be suggesting that you speak to your testing provider around that. And if you get them retested, who pays for the retesting? I think it would be reasonable to suggest that the employer pays for that retesting. And I think I have one or two more. So if conducting drug testing in the workplace, do we need to comply with Australian standards? I think that basically if you have a policy in place around drug and alcohol testing and it's a part of your contract, then that's the policy and the procedure that you follow, and that would be considered reasonable. And one more, let me see. How do we mitigate our risks with, no, I've done that one. No, I think that's all I have. That's about sending the presentation. So in saying that, thank you very much for your participation today. I know this has been short and sharp. I hope it's been informative. For those of you who wanted to contact me after the event, then you probably do have my email address, larry.forsyth @australianbusiness.com.au. This is my last webinar for the year. Thank you to those that have registered today, and I look forward to bringing you more webinars in 2015 from Australian Business Consulting and Solutions. Thank you and good afternoon.